A very warm welcome to Abhinav Sekhri to Not Why But How, a public policy podcast where big ideas meet real action. Presented to you by Kautilya Society, NALSAR Public Policy Group, this episode is done in collaboration with Indian Journal of Constitutional Law. At Not Why But How, we believe that good ideas are just the beginning. What truly matters is making them work. Not ivory towers, not endless debates, just sharp practical conversations on turning policy into action. My name is Namita Duntula. I'm a second year law IVM student here, and this is...
Hi, this is Karthik, and I'm a final year law student here. We are delighted to welcome Mr. Abhinav Sekhri, a distinguished legal professional specializing in criminal law, evidence, and procedure. An alumnus of National Law School, Bangalore, and Harvard Law School, Abhinav has returned to India to both practice and teach law in New Delhi. Beyond his legal practice, he is an avid writer, contributing insightful analysis on the Indian criminal law and procedure through his various scholarly articles and his blog, The Proof of Guilt.
So, sir, we have a few questions for you. So my first question to you is, as a practitioner of law in Delhi courts, you are also someone who writes extensively about criminal law. So therefore, what do you think about the practical and theoretical aspects that might, help that might help policymakers, and to what extent do you either listen to in capacity as a practitioner and an academic? What are the gaps in this area, and what can be done to improve these gaps?
No, so I'll answer a bit first, but I just wanted to clarify when you were asking what gaps in the area. So what area specifically do you have in mind?
Public policy making.
Policy making in law, and generally the field of law, right? So no, thanks for having me here, guys, and thanks for taking the time out. It's part of the reason why you start or continue to write when you started practicing was for me that gap that I felt was there immediately out of law school as a sort of fledgling practitioner, where I can't really say I was even a practitioner because technically I would not have given my bar exam yet. But even at that time, you sort of realize that there was that bigger gap between whatever you were reading in the classroom, and not just in terms of specifics of practice and procedure, but even like principles of law. So for instance, I specifically remember the rules in evidence such as hearsay or tainted evidence and things like that. And when you are seeing this in action, you see that courts are aware of what, like, people in court obviously know what is happening, but the language of court is very different. It's not as dumbed down as the classroom to make you appreciate what is happening. So, and at the same time, there are all of these other nuances that scholarship allows you to explore, which you don't have the time for in court, because your job, and as I've grown into practice, I've realized this more and more aggressively and unfortunately, in a sense, your job as a practitioner is largely to be honest and to be faithful to your brief and to do your best job as an officer of the court. You get time to think about issues, yes, but your job is not to really think about the issues beyond getting your client relief and beyond, making sure that you're doing your duty as an officer of the court to render the court assistance on the legal issues before it. So as a younger sort of practitioner, you had that much more time to think and you could do that. And there is undoubtedly that gap between law and practice, and theory and practice, if you were to say so. Is that something that can be avoided? I don't think it can be, because there will always be that gap between theory and practice, right? That's what I've sort of come to in a position, in a sense, over the last 10 years, that there is bound to be a gap, because theory will have that ability to sit, hypothesize and imagine like 5 different ways in which something can happen. So that is what its job is. Practice is not. Practice is very outcome oriented, and that is what it will always be. At the same time, I do think that, in terms of the questions that we sometimes see being asked of ourselves in court, there you see that, sometimes there is a gap that should not be there. So let's say what I'm trying to get at is there are 2 kinds of gaps here. broadly academia will never obviously interface with practice fully. It's not going to be a fully integrated system ever. It can't be, it shouldn't be. But at the same time, there are certainly gaps where both academia and practice should be better informed of each other, because that doesn't happen, we end up repeating the same mistakes or asking the same questions that we have been for years, which we need not spend so much time doing. And that in a system where you have such aggressive delays, you have so many problems in dispensing justice in a timely manner, you really don't have time to waste. And I think that's where that gap becomes a problem. And to your second half of your question about thinking where working on this can help in policy making, I think it definitely can help policy making, because that issue of delays, like I mentioned, is probably one of the foremost issues insofar as policy making within the sphere of law and justice is, where it is today. And thinking about getting academia and practice to work closer together and incorporating ideas from one into the other will definitely help come up with better solutions. So in fact, there was a book that I just read, Tariq Pe Justice, which is, I think, one of the co-authors is an alumnus of NALSAR, Ms. Jain. I think she's the alumnus from NALSAR in that. And their book sort of gives you some examples of this, especially where it comes to solving problems of delay, where the examples that they give you show you that there is that gap between the theoretical side of things, where you're coming up with solutions that are totally divorced from the actual context in which you want the solution to work. So I think there's definitely a lot to be done there.
As a corollary to your question, your answer, would you say that the criminal law academia in this country hasn't been doing enough to engage with the criminal law codes and the developments that have been taking place through Supreme Court and other institutions?
No, so I feel very uncomfortable in answering any question about academia because I'm not a part of it. So I honestly don't know enough. I am not in that setup, and frankly, for all I know, academia may be doing a lot, but as a consumer of that, you are a very different, you're occupying a very different perspective, where you are only getting what comes out of the publication machine, and the publication machine and scholarship is a different beast altogether, where only certain kinds of ideas will see the light of day. So I'll answer that question in my capacity as largely a consumer of stuff that comes out of academia, where I don't think that it's not a question of doing enough or not enough. It's a question of what is it that we should be doing, right? So it's not a question of just being responsive and writing critiques of judgments, or engaging with the Supreme Court or the High Court, or a specific High Court has dealt with this judgment, let's do a case comment, or well, this provision in one statute or another has various problems. I think that's one brand of scholarship that will never die out wherever we are, whichever jurisdiction we are in. But from my position as a consumer, what I have not read as much is what I'll say radical scholarship. Radical in the sense, and there are some people who are doing this in practice and policy, which ends up often ending with the lens of caste, because there it becomes a trope at a certain level, right? You expect only those scholars to be advocating for radical solutions, which places a burden on them that is not theirs to bear to begin with. Because I think radical solutions are what you need, or radical conversations such as why should we persist with the criminal process as it is. This is not to say, the problem in entering that conversation is that there are so many actors wanting to hijack that conversation, such as there will be conversations of the nature that we should Indianize the system, whatever that means. These are not new, by the way. In fact, if you go back in time, there are government reports right at the start where in 1950, 51, 52, government is asking for suggestions as to reforming the system. And there is a school of thought that is saying that, we should Indianize and go back to the Gupta period and whatnot to try and come up with answers. And you think about it, and the answer is, well, as a country and as a system of administering justice, it's just not feasible. So, but you still have to come up with solutions. And it was very instructive, in fact. And I think these were memos from the 50s to 53 that I saw, where the question was laid out in black and white. We can either take radical steps, suffer for a couple of generations, and maybe by the 1960s and 70s, whatever new system we enforce will bear some results, or we do whatever little chopping and changing we have to do to make the existing system at the time, which was the system that had been there for almost over a century technically, but actually practically it had been there almost over a century, but technically only in 1861 the codes sort of start coming in procedurally. So the memos are like, we can either chop and changes to make it work for us, replace Queen with Government of India, so on and so forth, or we really take a wrecking ball through this and come up with something new. The choice was, we can't afford to take a wrecking ball because we are an extremely poor country suffering with a geopolitical crisis of great magnitude. That is the reality that India sort of was birthed into, and we don't have the time or effort or energy to put into this as opposed to the real crisis of poverty that the country has to deal with. That then gets passed on and on and on, and we are now in 2025 where even though the new criminal codes came out, the Sanhitas, they are effectively, and now there is enough and more material to back this, they are effectively nothing but chopping and changing what was already there again. So radical scholarship and radical thinking around how can we reimagine the entire criminal process, I don't know how much of that is happening, because as a consumer I'm not seeing that much of it, but I'm sure there are people doing it. I am sure there are like PhD scholars and teachers who are going down those paths, and I think more of that is what we need today, personally, as like a consumer of scholarship.
Sir, have you, as you mentioned, the new criminal codes, have they changed anything for criminal lawyers like you in your day-to-day practices?
No, they definitely have. On the lighter side, starting with, we just need to now quote 2 instead of 1 provision. So where, for instance, in the Delhi High Court, you need to put both provisions in your petitions, and even in the trial courts, you are encouraged to write both provisions so that everyone knows what is it that you're asking for. On a more serious side, there is no escaping the fact that it's a huge administrative problem, and in Delhi you don't even see the tiniest sliver of it, because in my whatever little experience I have, and right now we're having this conversation for the benefit of listeners at the time that the Courts and the Constitution Conference is happening at NALSAR. We are here while Mr. Shamdevan was delivering an address which just ended, and he has the experience of 50 years behind him. Even in my 10 years of experience, I can tell you that law practice in metropolitan cities, tier 1 as you might understand it, Delhi, Bombay, etc., it is a different world to law practice outside of these cities. And the deeper you go, into, let's say, anywhere for that matter, even at the High Court level, even at the trial court level in big cities like, even Calcutta for that matter, I had an experience where judges would still be writing evidence by hand in some trial courts there. So what that means is that there is that much more work that they have to do, and to then be tasked with an exercise of relearning a code, practically that's really the most onerous task that these new codes have placed, because effectively all that you're doing is a relearning of the provision at the first level, because the provision underlying it is the same in most cases. There are very few provisions that are drastically different. And to then add that, to then force the administrative machinery to change their forms, their practices. It's funny because in matters that have done, let's say, in some parts, the forms that they were being used in the papers, they were actually forms that were pre-1973. So for the benefit of listeners, the last criminal procedure code had been enacted in 1973, prior to which India was using what was called the 1898 criminal procedure code. I have seen forms where the 1898 code was still being used, right? So then to expect 2 iterations is going to be very hard. There's no doubt about it. I don't know whether the digital divide will make things easier for some parts of the country. Definitely not for all, because again, doing this digitally will help. So that's the first big thing. Now, in terms of other problems or other serious like issues, honestly, I think I have personally felt it's still in a teething sort of phase, because the law, it's not even been a year. We are doing this conversation in March. The courts came into effect in July of 2024, and you're not really seeing the effect of it. I mean, one bubbling conversation that I have tapped into, thanks to like other fellow practitioners, is this issue surrounding, let's say, what is a technical issue in the law of evidence, where if you were to get any electronic evidence like a printout, you need to back it with a certificate, and the rules around these certificates have changed, but not many people have caught on to it. Many people in the form of all of us, like practitioners, judges, police, and everyone sort of, waiting for some clarity to come, because on anyone's reading of the law has only become harder and frankly, honestly, unimplementable according to me. I don't want to enter into the details too much, but no one's really gone ahead and dealt with the issue head on. Everyone's sort of tiptoeing around it, waiting for someone to just say what is in everyone's mind, that this is not really working, so let's just not enforce this provision. So it will be interesting as to how you'll see the system deal with these problematic provisions that are problematic, not let's say from a rights perspective, that are problematic from a system working perspective. And I think that perspective is what actually gets a lot of privilege in our criminal justice process, because I mean it has to work, right? You can't, provisions that might bring the entire system to a standstill are the ones that you will see great litigation around. So I think that's how problems will get developed. I don't think the provisions that are going to be rights based may get the focus that they deserve immediately. At the same time, conversely, I think the provisions that really might harm the system from working might not get any implementation at all, because very conveniently the system will turn a collective blind eye to them, because what matters is ultimately that the show must go on. So it will be very interesting to see how all of this develops.
You earlier spoke about the need for radical scholarship. In light of that, we would like to mention your article for IJCL's 9th volume, Article 22, calling time on preventive detention.
That wasn't radical at all.
I mean, certain people would definitely say so. But you broadly argue that it's time to get rid of preventive detention because Article 22 subordinates safeguarding individual liberties with legislative tyranny. Now, Article 22 is informed by something called the silos theory, where each article of Part 3 is considered to be a code in itself, leading to the understanding that they cannot be challenged against other fundamental rights in the Part 3. This is something that was upheld and stressed by the Supreme Court in AK Gopalan. However, it was subsequently watered down in multiple cases like R.C. Cooper and Manika Gandhi. However, the court still sees Article 22 as a carved out exception to Part 3. In light of this, do you think that the ghost of AK Gopalan, that is the silos theory, is still alive?
So again, I don't want to be overbearing, but I want to reframe the question to make it slightly more accessible. I think the issue is largely that, look, there is something called preventive detention, and I had once written a paper saying that it's a problem. Two things about that. One, the paper is just a sort of brief foray. It is by no means, a full attack as I would want it to be. And a big limitation on it was, and deliberate on my part, was that I had kept out one big problem with it at that point of time, which was its application to what is now the Union Territory of Jammu and Kashmir, but what was back then the state of Jammu and Kashmir, and the implications that were there for Article 22 when it came to Jammu and Kashmir's unique status at that point of time. My article didn't even sort of go into that for a deliberate reason, because the point was just to focus on preventive detention at large, and the issue that sometimes becomes when you talk about preventive detention in Kashmir is you think that it is a unique to Kashmir problem, which it is not. In fact, Tamil Nadu has probably higher preventive detention rates comparably than even Jammu and Kashmir as of now. What is preventive detention? Why is it a problem? And what was the paper? Preventive detention as a concept is, if you were to imagine the normal criminal system as basically reactive system, right? So where basically someone does a crime, then the criminal system kicks into action. Where, okay, there is a report that a crime has been committed, you go into whatever has happened, and then start things, and then you arrest someone because there is an allegation that you have committed a crime. Preventive detention is the opposite of that, where there is a suspicion that someone might do something bad, and the state wants powers arrogated to itself to intervene preemptively. It's like a preemptive strike for, Minority Report is the often abused example of this, the film and the book around it, where you sort of predict that someone might do something and you want to preemptively detain that person for a specified period of time on the basis of that threat of danger that they pose, right? So that is what preventive detention is. The problem is fairly inherent if you stop to think about it a little bit. Well, it's all based on predictions and risk and dangerousness, and you are sending someone inside on the basis of something that they have not yet done. This is a problem to start with. But then when you think about how preventive detention works in India, that problem gets magnified 100-fold according to me. Number one, you have preventive detention working to allow detentions up to 3 months without any sort of problem. Preventive detentions are not decided by courts, they are decided by administrative, sort of quasi-administrative tribunals that are involving judicial actors, but they are still not courts. They are conducted behind closed doors, their judgments are not published, there is complete secrecy around how preventive detention works, and it can be up to 1 year, which in case of Jammu and Kashmir was even higher, which is why Jammu and Kashmir was a separate problem for preventive detention. So when you add all of this together, preventive detention becomes a seriously bad thing, right? For any system that claims to be a system premised on respecting, rights and personal liberties and calling for the state to justify itself before it takes action. In writing something like Calling Time on Preventive Detention, the idea was simply this, that it just does not make any sense to have this power, largely because there are various ways to argue this, but it doesn't make sense on a very fundamental point, which is, why should the Constitution of India have a set of provisions that specifically legitimize preventive detention? Because the conversation then goes into automatically putting everyone else in a defensive posture. Let me develop on that idea. We, for better or for worse, are a system where the Constitution and its text are very difficult to challenge. I'm saying better or worse because for some things it is absolutely integral that we don't allow that document to move at all. But that's not true for all of its facets, right? So it has various hues to it. Some are so wonderful, one obvious example is the notion of equality that it forced upon this country's throats, right? It forced upon it. It still refuses to accept it. But the Constitution is the only document that is forcing it. And I was at a conversation around the new book by Gautam Bhatia, where one of the speakers took this idea, where they said that, it's like our fort. It's a fort, it is like a moat that the anti-equality forces can't breach. And you can't allow that fort to be damaged at all. That's very true. But at the same time, that same fort also has Article 22 that specifically says that the state can make laws for preventive detention and sets the thresholds around those laws at such bare minimums that there is no incentive for anyone to come up with a better system. So where basically the Constitution tells you and sets a floor that please don't make laws that are worse than this, that is completely incorrigible. There is, for the state, no incentive to really make a law that is any better than it. And that's another problem with preventive detention. Case in point, a specific provision of preventive detention that you don't actually have a right to be defended by a lawyer in these proceedings. What says it? The Constitution says it. And why was that provision upheld in a challenge? Simply this logic. Well, because it is part of the Constitution from the start. And so we can't strike it down, is what the Supreme Court of India held in this judgment called AK Roy another AK after Gopalan. But so which was the broad point in Call Time on preventive detention, that Article 22 has a very unique history to it. I don't want to bore people further by completely droning on about it. It served its purpose in the initial time. It really does not need to be on the Constitution anymore. Preventive detention as a concept itself has been part of statutory regimes even before the Constitution. It continues to be part of the Criminal Procedure Code as well. It need not have constitutional backing in the sense, which is what we mistake Article 22 for being. And that's the problem. The manner in which Article 22 is it's giving backing to preventive detention, which it is not intended to do. Please don't mistake me for saying that. But it allows itself to be mistaken for a provision that backs preventive detention. And I think it's time that it does go.
That perfectly segues into the next question. You believe that the legal community reveres the constitutional text to the extent that such intrusive ways of depriving personal liberty are acceptable, while the laypersons, especially the ones who face the brunt of such deprivations, most certainly do not. Has anything happened in the past 5 years which simply furthers your argument and the point?
It's actually a very difficult question because I don't think it's the legal community. I don't think the legal community reveres the Constitution, right? I mean, you have the Constitution is a battleground for the legal community, and I think right now you can't have it more expressly in front of you than at any other prior point in time. I think there are more and more conversations around, like in proper academia around this. You see it on the streets, you see it in courts. So I don't think anyone reveres it. At the same time, there is this unspoken pact that everyone also reveres it, because everyone agrees that it's a great constitution. Everyone agrees that it should not be. It has done wonderful things to make sure that the republic continues to stand 75 years in or whatever. Yeah. So there's no question about it. It's a very weird duality. So which is why I don't think that, people don't have a problem with preventive detention being on the Constitution. People do have a problem with it. Lawyers have a problem with it. Courts have a problem with it. At the same time, I think the issue of whether the problem is so high that we can do anything about it, I think the way is to really, ask it more openly. Let me put it this way. That one paper saying that preventive detention is bad and should go, the reason why you're talking about it is because there aren't that many that do it today. There are papers that will analyze it, there are papers that will study it, there are papers that will talk about, okay, preventive detention should be limited to certain circumstances, it should not be in certain circumstances. There's all of that. Where's the call to arms to say that, it's a bad thing, it should not be part of the Constitution, and there's your argument. So I think you're right, like in terms of just, clear writing and being clear-sighted around some of these issues is definitely a problem. At the same time, I think it's not true to say that reflects that, there is some sort of reverence of the Constitution or its texts. There are ample sort of arguments, critiques around it. It's funny that you say this, right? Because we're talking in the aftermath of Article 370 sort of being wiped out from existence. So there's clearly a very selective reference to the constitutional text, if anything. So yeah, I don't know whether reverence is the answer to why Article 22 stands. I think it's a logic of power and convenience. No government will want to pass any decision that limits, insofar as even if you think about Article 22, the amendments to Article 22 that were brought about in the wake of the emergency in the 44th Amendment are still not notified till date. It is the most absurd and interesting sort of legal thing where amendments to the Constitution were made, and it's almost going to be 50 years in 2027, and still those amendments have not been notified. So that really speaks to you of nothing else but power, and nobody would want to create or even limit preventive detention to that extent. that those constitutional amendments that exist have not been enforced.
Thank you, sir. I have a follow-up question. So the article concludes by questioning the public's apparent acceptance of preventive detention as a law enforcement tool. Why do you think this, in quotes, the most odious deprivation of personal liberty has become normalized, and what role can public awareness and activism play in challenging its use? Yes.
So I'll tell you where that thought comes from, and that thought comes from seeing and realizing that there are no two sort of separate train tracks or separate silos of what is the normal criminal justice system and what is the preventive detention system. They are basically part of a bouquet of options that the state has to deal with a problem as it sees it, where the state is just a loose term to refer to the police, the executive machinery, the courts, even for that matter, everyone. You have a bouquet of coercive action. It could be preventive detention under Article 22. It could be issuing notices under Section 107 of the Criminal Procedure Code, as it was then. It could be issuing an FIR and taking someone into custody. All of these are options. Why do I think there is an acceptance? Is because your normal criminal process is so badly out of tune in terms of really delivering justice normally, that there is an exceptional appetite for quick justice, preventive justice, do something justice, if I was to just say it that way. So where you have cases that will not end, you have trials that will go on for a decade sleepily without anyone realizing it, there is always going to be that appetite for the quick solution. And I think that's where it's very difficult to really generate support for the idea, because there is no question that there are individuals who are dangerous, and you need to have some sort of machinery in place to deal with it. There is no question about it. Which is why Article 22 and its problems are unique, which is where, if I was to give you an example, there is a coercive process in the form of what is Section 107 of the Criminal Procedure Code that deals with habitual bad characters in society, which is an entirely court-based process, right? So you have a judicial actor, open hearing, documents are given, notice is done, a lawyer defends you. That's one way to do things. Preventive detention is behind closed doors, you have no idea why you're in. The earliest you will get a hearing is probably going to be months, 2 months. You will easily be extended beyond 3 months. You only have a writ petition available to a high court. Your hearing will only happen months, if not years later, and by the time that the High Court pronounces that your detention is done, it's usually 7 or 8 months into a 1 year period. In fact, there were 2 judgments. I was reading them this past month. I think in both of them, the Supreme Court struck down preventive detention. So that means you have lost at the High Court and gone to the Supreme Court. Point number 1. Point number 2, in one, I think the person had spent about 9 months or 8 months in custody out of a period of 12 months. What's there? Right? So, which is the problem? You can't really explain this to people very easily. So, to say that public awareness will really help, I really don't think it will. Which is why I think that it is something that has to be chipped away at through, legislative intervention, through courts, where courts have to sort of now front up to the constitutional text. They've fronted up to it in some measure, when you dealt with some parts of the constitution recently. And I think Article 22 really is another part of the constitutional text that needs to be squared up and seen with in light of the 75 years of this republic and what that document means and what it was when you started out on that journey. And both things can be true. It might have been exceptionally necessary when India brought the constitution into force in 1950, and it may absolutely be atrocious to have it today, 75 years later. Both things can be true, and I personally think they are true. So yeah, that is the thought process behind what you were just reading out.
So last month, there were lawyers in Delhi who were protesting against the proposed amendments to the Advocates Act. Do you think these amendments welcome any changes or are harmful?
I have to be very honest with you. I was not part of those protests at the ground level to really be able to answer this. There were changes that were thought to be beneficial. There were changes that were thought to be absolutely harmful to advocates' interests. And I think right now the bill has been withdrawn anyway. So I think it's a question that need not be sort of gone into that way.
You are an off counsel at the Internet Freedom Foundation, which does a lot of work concerned with tech law and digital rights. What do you think are the primary drawbacks and criticisms of the DPDP Act? And broadly, what do you think are the policy initiatives that the government can take to address these issues?
I think so that's a great question, and I think this is going to become a headline issue over the next 8 to 10 months. I think I'll answer the second part of it first and then go to the first part of your question. The second part of it is transparency and open dialogue with stakeholders is definitely something that the government can do to try and deal with a lot of concerns that people have around the implementation of the regime. There's been so much smoke and mirrors around it already, and I don't think it is helping anyone. It is not helping any of the actors in the setup. And so I think just a lot of transparency in terms of coming up with the regime around the rules, taking feedback, being responsive to feedback, because let's be honest, tech is a space that is exceptionally open to regulatory capture across the world, and you don't need to really start thinking about it too much. There's not tech, there's big tech, right? So we know that. So I think we have to be very careful that we don't land ourselves up in the same situation, or at the same time we don't land ourselves up in a situation where we are wanting to just be exceptionally affronting big tech to sort of have some other collateral gains. And lastly, in terms of policy, acknowledging the fact that the state remains the biggest stakeholder in the lives of ordinary Indians, and therefore a regime that exempts the state from responsibility is a regime that is absolutely unpalatable, which is where the conversations have been so far. So on that is the second part of the answer. The first part of the answer in terms of problems, I think, are largely the state aspect of it. I think and you're seeing this right now with a lot of momentum being generated in respect of certain exceptions to the RTI Act regime that are being carved out using the DPDP Act. You can't roll back on holding the state accountable. And I think the problem that has been seen in the last, I think about 10 years now, since Shreya Singh's judgment, I think the last 10 years have sort of seen this where censorship is not the word, but I would say regulation. Yeah, I would say regulation of the tech space has become more and more opaque, more and more difficult to question at all levels. Be it at the start of the process, which is by way of draft policies, be it during that process by way of coming up with changes, etc., passing those policies, and then obviously challenging orders or decisions that may be passed. It is just becoming immune to any sort of meaningful check by anyone, that we may not realize where, because of the important role that tech plays in all of our lives. All of us are hooked on to the superhighway at all points of time. This part of this arm of the government may end up being so omnipotent and beyond question that we'll be in a lot of trouble. So I think that's where I fear the conversation going, where the DPDP Act is also going to become one another legislation that is going to just make the government even further beyond the pale of questioning, make decisions even further to challenge, make any sort of redress even harder to get, and you will just move yourself to a new normal, because that's what it becomes, right? After like a fight, think about Aadhaar for that matter. After a fight, right now there are only so many people who might still be holding out on Aadhaar, but over the course of 10 years, it's a gradual sort of war of attrition, if you were to think of it that way, where just by not budging, just by not dealing with court orders, and slowly the newsprint on it will shrink further. Slowly the population that is still holding out will sort of again dwindle into insignificance. And I think that just might be the pathway with DPDP and other acts to bring us to a situation where it's this side of the government, mighty, and the other ministries that will have so much power that we can't even begin to contemplate.
Absolutely, you're absolutely right. In light of that, do you think technology, especially digital rights, is the new frontier of activism for us, for the next generation?
It's so difficult to answer that, because again, I think it's a very we forget that there are so many realities to India, right? So to say that digital rights is the new frontier, absolutely it is a new frontier, but at the same time, it's not that it's the only frontier or that it's the most important frontier. It's definitely a frontier that requires as much attention as we can push it, but that doesn't mean that it becomes the only place of dealing with issues. Yeah, I think there's no question. I mean, it's an obvious answer. Yes, it is a very important frontier, but I think it's never going to be a situation where it's the only frontier as such.
Mr. Abhinav Sekhri, thank you for your insights and for helping us think beyond the headlines. As young citizens, our engagement with policy must go beyond critique. It must be about understanding mechanisms, questioning frameworks, and pushing for better governance.
Thank you so much for tuning in. Until next time, keep asking not why but how.
Thank you.